Alright everyone, we start off today with very big news, which is that the National Firearms Act may actually be going the way of the dinosaur. Good riddance, by the way, if it does. Link in the description. Now you can read that if you want. It's only 4 pages from the specific court document. A challenge to the NFA is being dovetailed with other pro-gun movements. It's a supplementary motion here that's been issued. And it's pertinent to the Bruen decision, which was of course made a few weeks ago by the Supreme Court. The Bruen decision at its core fundamentally imposes a challenge to the federal government specifically, and implicitly of course to state power, with regards to gun control. That is, that the wording of it, the one aspect of the wording that wasn't so limited, is that it imposes a litmus test that the government must show. It has the burden of proof effectively that gun control conforms to some prior tradition within the United States. That is, that at the times of the founders, when they were alive, we're talking the late 1700s, early 19th century, is there some doppelganger, is there some legal recourse for the government to resort to justify gun control? Was there some sort of gun control at the time that the people that actually penned the Constitution and signed onto it in the first place were familiar with, accepted, and didn't have a problem with? The fact is that that is a very short list. There are only a couple of forms of gun control in the United States that are remotely constitutional. The government has the capability of taxing interstate commerce, so that would apply. It certainly, unfortunately, I would say, has the ability to restrict importation, foreign ammo, etc. Does it have the right to do anything but fuck anything other than safety checks for the domestic manufacture of firearms, ammunition, etc.? No, it does not have that right. Does it have the right to tell you that you can't have an automatic weapon? No. Does it have the right to tell you that you can't own explosives? No. Again, people throughout most of the 19th century even used to make their own dynamite or purchase it just to blow up tree stumps. They did their own private workings on a regular basis. By the way, generally speaking, outside of large-scale mining operations or building railroads, people didn't tend to get injured by these things because the average person is not a violent psychopath. They owned machine guns. They owned Gatling guns. You can still, by the way, buy a Gatling crank. That's perfectly legal. I don't know if it's even needs a tax stamp, actually. You can put that on pretty much any rifle and pistol variant that currently exists. Whether it's pragmatic or not depends on the mag restrictions in your state. Again, does the government have the right to tax items attached to firearms? Dubiously, probably not. These are all now going to be embattled as the NFA is embattled in the court. This has been punted down to the lower court system by the Supreme Court decision under Bruen. Now, how they rule, of course, the Supreme Court has effectively commanded them to consider Bruen's wording very carefully in reconsidering some of these pro-gun challenges. So you've got mag restrictions saying high capacity, which doesn't really exist. Magazines, those are illegal. Weapons of a certain length, weapons of certain types. The challenges to not being able to sell to members of the militia aged 18 to 21, which is probably the most unconstitutional. The only other element of gun control that exists that can be, in a workaround sort of way, could be sensible, is arguably background checks, specifically for distributors that are registered. And the only reason that I say that, and this may not sound like a libertarian opinion, is because the founders would have found it perfectly appropriate to prevent people from owning firearms if they were a criminal lunatic. What is a violent felon? They've gotten out of prison, they've served their time, but they are still what the founders would consider to be a person of distasteful mentality. They would not have found that that person should be allowed to, in many cases, vote, to own firearms, and to do some of the other things that people do, because they would have been put in an asylum back several hundred years ago. You have to actually have a system in place to be able to check. I don't believe in disarming non-violent felons. I don't believe in red flag laws, pre-crime, and so forth. So those are the only 3 things the government really has any right whatsoever to legislate on with regards to firearms. The other part of Bruen that comes into focus is that it argues that in some states, and certainly at the federal level, that a litmus test has been imposed on the Second Amendment and its free exercise that is not applied to any other amendment. Nobody says that you need to get a license to speak freely. Nobody says that the right to privacy is somehow hazarded because you have a certain opinion. It's assault privacy. You're expecting a little bit too much privacy, so it's not allowed. The 10th Amendment is not construed as only protecting the original 13 colonies. The right to trial is not suddenly thrown away because the crime that you committed, allegedly, is just well beyond the pale, and so you don't need a jury trial or something. In no other case in the entirety of the Constitution is the same litmus test imposed that is imposed on people's right to keep and bear arms. What the Supreme Court reiterated, and it goes without saying, it never should have needed to have a case in the first place. There shouldn't never have been an NFA of 1934, effectively. What they're saying is that that's unacceptable. The Second Amendment and its free exercise, simply because guns can be destructive, does not fall into a totally different constitutional category as all of the other amendments. I think there is a chance that we'll see the death of the NFA, therefore, in the next few years. We have to wait for the lower court decision, and SCOTUS may or may not take up the case. It could be that they punt, like they might have done with Roe. They could have gone with Roberts and said, well, the Mississippi abortion law is perfectly acceptable with us. 8 weeks is fine. Doesn't violate Roe, but Roe is upheld. They could do that with the NFA. They could do that with these cases, either by refusing to take them up or by issuing limited language. They could say, well, the NFA is fine, but these particular provisions within the NFA are not acceptable. We find that they violate Bruin. We find that they violate the Second Amendment. My hope is that in the current incarnation of the Supreme Court, and there is reason to hope after the Bruin decision, the fact that they even took it up and the writing was on the wall as to what their decision would be, gives me hope. My hope is that they decide to grant this trial, if it gets to the Supreme Court. If the lower court sides with the plaintiffs, of course, could be unnecessary. The NFA could be effectively nullified at that level. The government could appeal it to the Supreme Court and they say, nope, fuck you, sorry, we're going with the lower court's decision. You can't impose the NFA anymore. My hope is that they do grant it its day in court and they strike down the NFA, effectively ending virtually all federal level gun control. Again, if you go by the semi-originalist Bruin decision and you look at the historic landscape of gun ownership throughout the United States, certainly prior to Crookshank, so for almost the first 100 years of the United States, there was butt-fuck nothing with regards to gun control. The only gun control technically that you have is out in the Western Territories, which were not incepted as states. The local sheriff could tell you to check the guns at the door before you go into the bar and stuff like that, because of course it's not a full state. It's a territory. Totally different legal framework that was used in the hinterlands. It was directly democratic in many cases, and people sort of did their own thing. By the way, not nearly as violent as people historically believe it to have been. Yes, people were executed and fed to the hogs in Chinatown and Deadwood and things like this. The gunplay sort of thing was not actually that common, and at the same time, there were plenty of duels happening in other parts of the country. Just instead of revolvers, they used their little pepper boxes and shit like that. Very genteel. It's different from those rubes, those rustics out there in the territories with their buffalo hides and their campfires and so forth. We have better guns here. They're more polished. The ivory handles probably. I hope the NFA does get destroyed. There's no reason for any gun control in the United States. It's not constitutional. It never has been. Crookshank was overturned after over 100 years. Why can't we overturn the NFA? At the very least, the states are the only entities that should be capable of imposing any sort of litmus test on guns, and that should be exceptionally limited in nature. This would be a boon. It would also be a boon, by the way, to U.S. manufacturing and jobs. And I claim that it's also pragmatic. Yes, you would get more shootings, potentially. Then we'll just admit that up front. Yes, if you have mail-ordered machine guns, psychopaths may occasionally obtain them. That's very sad. Not that they can't obtain them already if they've got a fat wallet. They are legal, you just can't manufacture them. I argue, though, that if you have a militia, a core population, that is more well-trained with guns, that understands them, understands how to use them safely, how to clean them, target shooting, they know how to hit what they're firing at, you get a better military, because we've got a volunteer military, and one of the biggest advantages that we've had for our entire existence as a country is that because you have a well-armed population, the people, whether volunteering for service or being drafted, they already know how to fire guns. And again, in the first 100 years, they were using effectively the exact same weapons that a military would use. Lately, post-NFA, they've been robbed of that fundamental human right to defend themselves ably and to fully participate as members of the militia. Yes, the Supreme Court should strike down the NFA. It should be gone. There should not be any federal level gun control in the United States. If you think that this is going to lead to a rash of mass shootings, well, just look at the legacy media coverage. They would have you believe that that's the case now anyway. So what the fuck changes? Absolutely goddamn nothing. Yes, it is pragmatic that I should be able to purchase or even create my own automatic weapon. Because it's just going to sit there unless I take it to the range or something. It's not going to shoot anybody who's not trying to shoot me. That's about all. Peace out.